Hello and good morning, everyone. Thank you for joining us for today's webinar. We have a little over 500 registrants for today's webinar, so we're going to give folks a few seconds to log in and get situated. We'll start our webinar in about 1 minute. All right, we're going to go ahead and get started. As we just mentioned, we are here to present today on Nebraska's paid sick leave. As hopefully all of you know, Nebraska has a new law called the Nebraska Healthy Families and Workplaces Act. And we're going to go through that act, its requirements, and hopefully answer some commonly asked questions here today. My name is Tara Paulson, and I'm joined by my two colleagues, Mark Fahleson and Julie Schumacher. We're really glad that you have chosen to spend the next 60 or so minutes with us, and hopefully we get a number of your questions answered today. Also want to give a special thanks to Zell Human Resource Solutions, who was our co-sponsor of today's webinar. All right, let's go ahead and get started.
So there's a famous quote attributed to Otto von Bismarck, also attributed in one form to Mark Twain, that laws are like sausages. It's best not to see them being made. And the focus of this webinar, as Tara mentioned, is the Nebraska Healthy Families and Workplaces Act, which was adopted by Nebraska voters in November of 2024 and was recently amended by the Nebraska legislature. In fact, Governor Pillen just signed it into law on June 4th. There certainly will be other webinars by other organizations on this topic. Many of them may go through the nuances of what used to be in there. Here's what the voters approved, but here's what the legislature considered but did not adopt. We're not going to go down that route because at this point, frankly, it doesn't matter. We're going to focus on what the law actually is. What if you had to look at the sausage, if you will, what's in the sausage, not sort of how it was made. Essentially, what are the ingredients? So let's go ahead and start unpacking the ingredients of this particular act. So think of it in terms of recipes, right? Recipes have various ingredients. And so we're going to break down the ingredients of the Nebraska Paid Sick Leave Act, hopefully addressing many of the questions that you may have.
So in breaking down what's in this law, the first ingredient is employer. So stated another way, which employers are covered by this new act, or who is an employer for purposes of the act. Employer is broadly defined. Under the new law, an employer includes any individual, partnership, limited liability company, association, corporation, business trust, legal representative, or organized group of persons who employs 11 or more employees. So it doesn't matter how the entity is organized or not organized. Key is 11 or more employees. This new law includes nonprofits, but it excludes the United States and the state of Nebraska and its agencies, departments, and political subdivisions. So if your organization is a governmental entity, you are excluded. If your organization has employee totals that fluctuate between or below and above 11 employees, you're encouraged to visit with your employment law counsel to get further guidance.
All right, so that is the definition of employer under the Act. And now we're going to take a look at the next ingredient. The next ingredient in the Act is one part employee. Who is an employee for purposes of the Nebraska Healthy Families and Workplaces Act? It's a defined term under the Act, so let's take a look at it. The final law contains a new definition of, quote, employee, and how it reads is an employee means, quote, any individual employed by an employer. To employ means to permit to work by an employer pursuant to an employment relationship. The definition expressly excludes each of those bullet points that are on this slide before you. It does not include an individual owner-operator, which is intended for over-the-road trucking. It does not include an independent contractor. If you are someone who has participated on our firm's past webinars, you know that determining whether someone, a worker, is an independent contractor or employee can be a difficult task, so just keep that in mind. The Act also excludes an individual who works in Nebraska for fewer than 80 hours in a calendar year. It also excludes an individual who is employed in agricultural employment of a seasonal or temporary nature. So let's pause for a second there. If you've joined this webinar and you're an organization that is in ag, this is not an ag exemption. There is no ag exemption under this act. The exemption does apply to individuals employed in an ag context, but only if they are employed on a seasonal or temporary basis. Additionally, the Act excludes employees as defined under a specific federal statute that is subject to the Federal Railroad Unemployment Insurance Act, and it also excludes any individual who's under 16 years old.
So again, the next ingredient we want to talk about is the actual paid sick time. So the first question is, Julie and Tara mentioned, you first have to decide who is an employee. Second, decide who is a covered employer under the Act. And then if so, if you meet both of those elements, what obligations does it impose upon employers to give those employees who are eligible under the Act? Depends upon whether you're a small business or what we'll call other employers. Small business for purposes of the Act is defined as an employer with at least 11 but less than 20 employees during a given week. It includes full-time, part-time, temporary employees. It's somewhat clear from the Act, although not 100% certain, but one reference to the payroll method of calculating, again, whether you're a small business and how many employees you have. What do we mean by that? There's a line of case law arising under Title VII and the various other federal discrimination acts that determine how do you decide who is an employee when counting whether you're covered or not. And essentially, they look at your payroll. So what they'll take the current calendar year, whenever the incident or alleged violation occurred, and the preceding calendar year, and they'll look at each work week and look how many employees did they have on their payroll on that particular work week. Payroll doesn't necessarily mean working. Payroll means that they're actually still employed by you, even if they're on a leave of absence, even if they were on vacation, even if they're on work comp leave. So they're going to look at that payroll to determine during week one, how many employees do we have? During week two, as long as you have at least 20 or more calendar work weeks during the current year or the preceding calendar year, you're covered. And so again, at least 11, but less than 20, and that's the method they're going to use. Let's assume you qualify. Let's say you got 15 employees, clearly, and you're a small business. Employees under that act for a small business can earn and use up to 40 hours of paid sick leave a year. These same requirements apply to the other employers who are larger. And so if you have 20 or more employees, again, calculated the same way, those employees can earn and use up to 56 hours of paid sick leave in a year. What do we mean by year? We'll talk about that here in a minute. So again, year in that instance is certainly a topic of conversation with some of the questions we've received already from employers. Here's another way of stating it if I wasn't clear on the previous slide. If you are an employer of 10 or fewer employees, you're not covered by the Act. If you have between 11 to 19 employees, you're covered, and you have to allow employees to earn and use up to 40 hours of paid sick leave each year. If you have 20 or more employees, same requirements, but they can earn and use 56 hours of paid sick leave in a year.
All right, so now you know who an employer is under the Act, you know who an employee is under the Act, you know a little bit about the paid sick time and what accrues or what an employee can earn in any year based on whether the employee works for a small business or other business. Now let's take a look at the leave calculation. So the law provides that accrual of leave does not start until an employee has had 80 hours of consecutive employment. After that, the paid sick leave accrues at 1 hour for every 30 hours of work, up to those accruals per year, as Mark mentioned, 40 hours for a small business and 56 hours for all other covered employers. Year is defined by the Act as a regular and consecutive 12-month period as determined by the employer. In most instances, that would probably mean the employer is choosing a calendar year. However, the employer can choose any 12-month period, which could be based on the employee's anniversary date, for example. Sometimes that can create some administrative headaches, but you will get to decide what your year is for purposes of this act. If you have a current PTO or paid sick leave policy and currently allow employees time off, that is going to count towards your 2025 obligations. Additionally, the Act requires that an employer is required to provide employees a statement on each regular pay period. On that particular statement, you have to have the following information. You have to include the amount of paid sick time available, the amount of sick time taken, and the amount of pay the employee has received as paid sick time. This requirement under the Act can be satisfied with an online system, which the employee has access to. At the end of the day, the employer is going to have to demonstrate to the Nebraska Department of Labor how many hours the employee worked, how much paid sick time the employee accrued, and how much paid sick time the employee was permitted to use. So here's a little something to keep in mind. Here on this slide is a cap with an X marked through it. The reason for this, and hopefully this helps drill this home for you, there is no cap on accrual of paid sick leave. Under the Act, it states, accrued paid sick leave shall be carried over to the following year. However, a small business is not required to permit an employee to use more than 40 hours of paid sick leave per year, and other covered employers are not required to allow employees to use more than 56 hours of paid sick leave per year. The Act also tells us that in lieu of carryover from one year to the next, employers may pay an employee for unused paid sick leave at the end of the year. Let me state this a little bit differently. Although you as the employer only have to allow an employee to use either the 40 or 56 paid hours of sick leave in a year, if an employee does not exhaust those hours in a given year, those hours are going to carry over to the following year. And in that following year, that employee is permitted to earn up to either those 40 hours or 56 hours of paid sick leave. So the amount that rolls over from year to year, there is no cap on that amount. So if an employee in a given year uses 0 paid sick leave, they're going to be able to carry over all of that accrued paid sick leave into the next year unless you would choose to pay it out at the end of the year. So again, those leave banks, paid sick leave banks, there's no limit on how much can continue to roll over year to year, but you as an employer only have to allow the employee to use the 40 or 56 hours of paid sick leave per year. Lastly, there's a question we've received questions as what is the amount of paid sick leave? What you're going to look at is the same hourly rate for each employee that they earn during hours worked. If you have a situation where you have employees that aren't paid kind of an hourly basis, instead they're paid on a commission basis or piece rate wise, or maybe mileage or a fee for service basis, what the Act tells us is we're going to be looking at the average weekly wage as calculated for workers' compensation purposes based on a 40-hour week. So that's how much paid leave you have to provide.
So that issue of average weekly wage is often something that is litigated quite often in the workers' comp setting. So to the extent you do have one of these unique pay arrangements, chances are there is some precedent under the Nebraska Workers' Compensation Act, which will further delineate what you have to include in determining what the employee's rate of pay is for purposes of this new act.
So continuing with our recipe analogy, the The next ingredient in this legislative sausage is the specified reasons for which a covered employee can use paid sick time. The bill is for paid sick leave, so does the employee have to be sick to get the leave? And is it only if the employee is sick? Let's see what the law says. So under the law, covered employers must provide eligible employees with paid sick leave for all of the following reasons. A is the employee's mental or physical illness, injury, or health condition, an employee's need for medical diagnosis, care, or treatment of a mental or physical illness, injury, or health condition, or an employee's need for preventive medical care. B, it says it must be provided for care of a family member for all of the same reasons listed above, or in the case of a child, to attend a meeting necessitated by the child's mental or physical illness, injury, or health condition at a school or place where the child is receiving care. Or C, finally, due to a public health emergency, which obviously harkens back to COVID-19. This one includes an employee's need to care for a child whose school or place of care has been closed by order of a public official due to a public health emergency.
As is noted on the slide, the term family member is broadly defined. It includes any individual who's related by blood or whose close association with the employee is the equivalent of a family relationship. The point being how broadly that is defined, chances are that term, God forbid you get before court or the Department of Labor, they're going to very broadly and liberally construe that. So essentially, if an employee can show that this person means as much to me as family, chances are that would cover what's necessary under this act. All right, next ingredient we will touch upon briefly is the amount of documentation that you can require or request from an employee who perhaps is seeking some type of leave. All right, first one, paid leave to be provided upon employee request. Please understand that the law as signed into law by Governor Pillen is silent as to whether the employer may require a written request. Previously, it said it could be an oral. Again, you're going to have a policy on this stating the manner and method in which the request is to be made. And so given that the law is silent, you can, in fact, we believe, require a written request, but understand that the law as initially proposed was simply an oral request. You can also, according to the law, as signed into law, demand or require that the employee provide the anticipated duration of the leave. So again, if they have a medical condition, they know they need to be out a week, perhaps due to surgery, you can require that they tell you what the anticipated duration is. The act is very clear. You need to have a written policy specifying the requirements of the process for an employee to make a request. Think of it in terms, although it's certainly not to this level of detail, like the Family Medical Leave Act, right? So you may have a form which the employee makes a request. You can ask for certain information, and then you should certainly provide them with a response as to whether their request is granted or denied, and if so, why. Understand that if it's just a request, hey, I'm calling in sick, or I've been out sick today or yesterday, in those situations, generally you cannot require the employee to provide any type of note. The employee can just simply provide a statement stating, hey, I need to be out. A medical note for absences of less than 3 consecutive days is allowed but not required under the act. And so the employee can simply give you a statement saying, I was sick, and that should be sufficient under the act. One unique thing, we've seen this happen perhaps more in the restaurant industry, a little bit in the childcare industry, is that you can't require employees to find a replacement in order for them to take paid sick leave, meaning it's not their obligation to make sure that the employer, the organization is adequately staffed. And so it cannot be a condition for the paid leave that they go find someone to fill their shift. And again, as I mentioned earlier, the act says the employer can require reasonable documentation when the absence is three or more consecutive days. And reasonable documentation is defined by the act as documentation signed by a healthcare professional, or again, a written statement signed by the employee. So a very, very light standard as far as the burden placed upon employees as far as when they make a request.
Another issue we want to touch on as we're going through this are the key dates under the Nebraska Healthy Families and Workplaces Act. As you can see on this particular slide, by September 15th, 2025, or commencement of employment, whichever is later. Employers have to provide written notice to employees that beginning October 1, employees are entitled to paid sick time. That notice also has to state the amount of paid sick time, the terms of its use, that retaliation is prohibited, and include the Nebraska Department of Labor's contact information. Another key date is October 1 of 2025. This is when the paid sick leave requirements go into effect and accrual for eligible employees must start. Employers have to provide this notice. Again, if you have a physical office, you're going to provide it in that physical workplace. If you have employees that primarily telework, the Nebraska Department of Labor has told us that you can provide this notice by electronic communication or by a conspicuous posting in a web-based or other app-based platform. The Nebraska Department of Labor has assured us that it will be providing written model notices and postings prior to that September 15th, 2025 deadline. So we should be seeing that notice and those postings from the Nebraska Department of Labor in the coming months.
All right, next ingredient, enforcement. This, again, don't need to get into how the sausage was made. Let's just talk about what the law is, as signed into law by Governor Pillen just a week ago. The act will now be enforced by the Nebraska Department of Labor. There is no private right of action. What does a private right of action mean? You can hire a lawyer to bring a lawsuit on your behalf if you're an employee to challenge an employer's perhaps denial of a request for paid sick leave. Rather, it is up to the Nebraska Department of Labor to enforce it. That generally would be started by an employee filing a complaint with the Nebraska Department of Labor. They would investigate and then determine whether there's reasonable cause and whether some type of citation and penalty should be issued. Again, interestingly enough, the fiscal note, which is fancy legislative jargon with how much is this thing going to cost, it didn't indicate that there's going to be additional costs or expenses incurred by the Department of Labor to enforce this act. So I don't think they got more money to enforce this, which means they are not hiring additional employees to enforce this. So we'll see how many complaints are actually filed in the first year after this goes into effect and see whether the Department of Labor gets inundated with complaints under this act. Understand that the penalties can be significant, up to $500 for the first violation and up to $5,000 for second or subsequent violations. Again, that's significant. Also, for those organizations and businesses who do work with the state of Nebraska or any of its political subdivisions, if in fact you are cited and assessed a penalty by the Department of Labor and you fail to pay it or to fail to successfully contest it, then you will be prohibited from contracting with the state of Nebraska or its political subdivision. So it's kind of a contract bar as an additional penalty on those organizations that do business with the state or any other governmental bodies in Nebraska.
All right, before we maybe get to these next questions, we have been receiving a number of questions from clients and others related to this particular new act, how do folks comply, what's required. And so we tried to combine as many of those common themes as possible in these next few slides to ask not only those commonly asked questions, but also to provide you answers, at least as the law is written today, in response to those. So Julie, you're going to kick us off and read questions for us.
Sure. So the first question is, in addition to the written notice requirement, is there a poster requirement, and what does that poster need to contain?
Of course there's a poster requirement. Don't you love how we now have these multiple posters and it's got, again, you can actually buy them. There's companies that sell these darn things and make money off of it. But the number of posting requirements continues to grow with each new employment law that gets adopted. And so, yes, there is a poster requirement. The Act specifically provides that employers shall display a poster that contains the requirements of the law in a conspicuous and accessible place in each establishment where employees work.
Pause. What does that mean, Mark? Right? Like
You know,
conspicuous and accessible place in each establishment.
you're not hiding it under the sink in the kitchen, right? So you got to be able to. It's got to pass the smell test, right? It's got to be reasonable. So in most of your organizations, and you do this already, it's in the break room. It's perhaps in a room where employees typically are at some period of time throughout any given day. I could think of countless examples where we've had investigations, and one of the first questions a federal or state employment investigator will ask, I need to see your postings. We want to be able to show those to them, right? We want to take them right to the break room where all the employees go, as opposed to opening the cabinet and showing them we've actually hidden it under the sink or don't have it at all. So again, just make sure it passes the smell test where you put it and the employees can actually see it. If you're an organization that doesn't have a physical workplace, let's say a construction company and your employees move from job site to job site, or the employee teleworks or performs work through some type of web-based or app-based platform, the employer has to be able to demonstrate that they provide notice of this information via electronic communication, not unlike the written notice that Tara mentioned earlier, again, the posting. Another interesting nuance, and this is a fairly new development in employment law, but continuing, given the diverse workforce that we certainly have here in Nebraska. That poster must be in English and any language that is the first language for at least 5% of your workforce. But the legislation thankfully put the burden on the Nebraska Department of Labor to actually create those posters and to distribute them. And so if the Department of Labor has created a poster, say for Spanish-speaking employees, you have at least 5% of your employees who are Spanish as their first language, you need to have that poster up as well.
Okay.
All right, here's the big one.
Nobody's asked this question by far. Nobody wants to know the answer to this one.
Okay, the question is, we already have a PTO policy. Do we need a separate paid sick leave policy too? Mark and Tara.
All right, so
maybe.
The Act provides that any employer with a paid leave policy, such as a paid time off policy, who makes available an amount of paid sick leave that is equal to or exceeds the requirements of the Nebraska Healthy Families and Workplaces Act, and that may be used for the same purposes and under the same conditions as the paid sick time under this Act, is not required to provide additional paid sick time under the Act, and is not obligated to allow the employee to accrue or carry over benefits beyond the employer's existing paid sick leave policy. So again, Mark kind of highlighted this. It kind of depends, right? As noted by some guidance that was issued by the Nebraska Department of Labor actually yesterday. There was a question and answer posed on this guidance on this issue. The question was, is accrued paid sick time required to be paid out upon separation of employment? The answer that the Nebraska Department of Labor provided was no. Paid sick time is not required to be paid out upon separation of employment. However, should the employer have a combined PTO policy that combines vacation and sick leave, all accrued but unused paid time off shall be due as wages pursuant to the Nebraska Wage Payment and Collection Act. So that may cause you to choose to have a separate paid sick leave policy that's separate from a PTO policy, because you do not have to pay out paid sick leave upon time of termination. There's kind of an interesting question still percolating as to what do organizations do that currently have an unlimited PTO policy. Since the recent amendments under the Act make clear that so long as you have another leave bank that qualifies and meets the same requirements as under the Act, there's no need to require accrual or carryover. So you could conclude that that type of unlimited PTO policy could remain in place and would be compliant under the new Act. One of the things that's interesting is before our webinar here, even just this morning, we as a group were discussing all of the open issues that still exist as to whether you're going to choose to continue on with just your PTO policy, assuming that it meets the requirements of the Act, or whether you're going to have a separate paid sick leave bank that complies with the Act. Again, still quite a few unanswered questions, but at least according to the guidance that we received for the Nebraska Department of Labor, and as the language is set forth in the Act, you can just use your existing PTO policy if that is something that you choose to do.
So Tara, Julie, let me ask you this question. Have you ever seen, when you're reviewing an employee's policy or employer's policies or handbook, have you ever seen an employer that has a different PTO or vacation policy, or does every employer have the same? Now, that's a dumb question, right? There are so many variations on these policies, and every organization does it just slightly different. The accrual rates may be different. And so for us to give a blanket answer to say, we already have a PTO policy, that's good, lock and loaded, you're fine. We can't give that blanket answer, but you need to be able to consider, do we want to explore a separate paid sick leave policy, or do we want to simply make sure that our current one complies? The obvious downside, as Tara mentioned, if you're just going to keep your current PTO policy, with the end of when the employee separates, you got to pay all that out. So if they've accrued and haven't used some, you got to pay that out to the employee. It's abundantly clear from the Paid Sick Leave Act that if you have a separate paid sick leave policy, that does not have to be paid out upon separation. So you got to weigh those risks and benefits. And so, Tara, Julie, where do you think you land today if you were advising just a generic organization? Are you going with lump it all under a PTO policy, or you wanted to have a separate PTO and a separate paid sick leave policy?
I think for me, if I was to get that question and ask to provide an answer today, again, not seeing what the employer's policy is, maybe they're just creating it for the very first time. My suggestion is going to be to have two separate sick leave banks, two separate leave banks, one perhaps for PTO vacation and one for your sick leave. The reason for that would be is you can make sure then that you are compliant with this new law under if you have this separate sick leave bank, you can make sure that you're tracking hours taken under the paid sick leave bank differently than you can under a general PTO policy. Traditionally, you're not going to be asking why someone is taking PTO. So then you have some assurance that if they're using that paid sick leave bank, it's for a purpose that this act requires it for. So my answer today would be to have two separate leave banks. I think a question you can ask yourself is whether you would maybe reduce your PTO leave to make room for this paid sick leave, meaning it doesn't necessarily mean that you now have to offer this 40 or 56 hours of leave under a newly created sick leave bank. You could actually kind of reduce your PTO so that you as the employer maybe are not having to offer additional leave if that wasn't something that you were contemplating. Mark, Julie, what would you add or do different?
Yeah, I agree with all that. And another reason why, at least for the remainder of 25 and perhaps through 26, for you to have separate policies, meaning keep your PTO policy, have the paid sick leave policy that is compliant with the Act, is we're trying to answer the questions as they come in. But I'll be honest with you, some of these we just don't know the answers to. We can give you our best legal guess. But my guess is in the next 18 months or so, we're going to have more clarity on how the Department of Labor actually interprets the Act. And so hopefully in that 18-month period, we'll have a better idea on, whether if you want to stick with a straight PTO policy, what are the nuances to that to make sure you comply with this law. So it's kind of the safer route for now. It's a headache. We understand that, but that's what the law requires.
Mark and Julie, help me remember, in the slide coming up, do we talk about having to keep track of accrued but unused banks at time of termination?
I don't remember, so let's talk about it right now, Tara.
Okay. Well, so the Act also has a provision in it that tells us that when an employee separates employment, we went over this, you do not have to pay out that accrued but unused paid sick leave at time of termination, but you are going to have to track it for up to a year. And the reason for that is under the Act, it specifically says if someone is rehired within a year, they have to start with the same leave bank that they had with you at time of termination. So that's a little bit different than a lot of us have ever had to do in the past. If you have an employee that leaves, let's say they've got 20 hours of accrued but unused paid sick time, you're not going to choose to pay that out at time of termination. Act tells us we don't have to do that. But then let's say that they have a change of heart 6 months later, they reapply, you choose to hire them, they have to start with that 20 hours of paid sick leave under a provision of this act. They don't have to work for another 80 hours of consecutive employment before they start accruing. They get to start with that leave bank. So again, that would be another reason why you might want to consider having the two separate leave banks, just so it may make it a little bit easier to track that.
Good point, Tara.
And maybe we'll cover it in the slide coming up.
Okay, so the next question we have here is, I read something about paid sick leave not starting to accrue until the employee has worked 80 hours of consecutive employment. What is consecutive? Does the 80-hour clock start October 1st, even if the employee has worked for us for 18 years?
So consecutive is not defined by the act, but we looked at some other states that have adopted similar laws and tried to figure out how those were defined. One state in particular defined consecutive employment as the uninterrupted and continuous employment for 80 hours. Again, not sure that helps me. I think what's intended is there's no break in employment, no separation. They remain on your payroll, and once they've hit that 80 hours, that's when they begin to accrue. As far as the second question, does the 80-hour clock start on October 1st, and if the employee is a long-time employee? Technically, yes. But I mean, look, the reality is you're going to have this system go into place, and for calendar year 25, given that it goes into effect October 1st, we're not really talking about a lot of hours, and they probably aren't going to get up to the maximum by the end of the calendar year. And so it's probably a small question that I'm probably not going to lose a lot of sleep over. And again, if we're worried about a senior long-term employee, don't you want to just make sure they have adequate time for leave, whether it be for vacation or sick leave? Finally, again, there's going to be a question when you come up with your policy. Do we front load it? Let's say you're a larger business. Do we on January 1st just put all 56 hours into the bucket as opposed to have them accrue it? You have that right. You're not required to. Obviously, there's some downside to that for the employer, and that the employee could work for you on January 1st, get their 56 hours, then suddenly, again, maybe legit, sometimes not legit, claim that they were ill, and they use all 56 hours of paid sick leave and then leave. So since you've given a benefit for essentially 1 day of employment on a calendar year without getting some type of benefit for the organization. So you're going to have to discuss those nuances with your employment and labor law counsel to make sure you get a policy that actually works for your particular organization.
Hey, before we move on to the next question, though, let me ask maybe a corollary to it. And I think in answering it, you're going to be thinking back to what the definition of an employee is under the act. Let's say that the organization only has an influx of workers in the summer because they hire a lot of temp employees to do the extra work that is required in the summer. Are we still having to provide this paid sick leave to those temporary or seasonal employees?
Are they in agriculture?
I'm going to say no. So do we have to provide it?
I think the answer is yes.
I think the answer is yes as well. So again, we did cover this on one of the first slides when we talked about the definition of an employee. While employees that are employed in agriculture on a seasonal or temporary basis are not covered employees under the act, if you are an organization that is not agriculture and have temp employees or seasonal employees, you're going to have to provide this paid sick leave, even if these individuals maybe only work 3 months for you. You're still going to have to provide these same paid sick leave benefits, assuming you're not in agricultural. In ag.
Would that include a paid summer intern?
I think the answer is yes again.
Yeah, agreed. Unless it's not in ag. And let me, again, this may not be interesting to many of you. It's interesting to me, so I'm going to talk about it anyway. Agriculture it's not as broad as people think it is. And my guess is, we don't know the answer to this, but that the Nebraska Department of Labor, if that issue comes up, and an employer says, well, we are ag and we have seasonal or temporary workers, therefore they're not covered. What's meant by ag? The Fair Labor Standards Act, there's been a ton of cases since 1938 defining what ag is. There's actually two separate definitions. One is the traditional sense, and that is, again, actually working with livestock or, row crops, things of that nature. And there's a broader sort of secondary, sort of those things are ancillary to that, but trucking generally is not. And so just because you happen to work in the ag sector doesn't mean you qualify for this ag, particularly I won't call it an exemption, but where you have seasonal or temporary workers in the ag setting, just because you work in the ag industry doesn't mean you qualify. So we'll have to get more information from the Nebraska Department of Labor. What we don't want is for your organization to be on the receiving end of a complaint because you didn't comply with it. So again, be sure to talk to your employment and labor law counsel to get more information if that is one of your concerns.
Okay, moving on to our next question. Our employee levels fluctuate between 18 and 22 employees depending upon the season. Are we a small business under the Act or one of the other employers that has to offer 56 hours per year?
All right, so we know small businesses include employers that maintain between 11 and 19 employees. Mark talked a little bit about that payroll method. So it's an employer who maintains between 11 and 19 employees on its payroll and each of 20 or more calendar weeks in the current or preceding year. So it doesn't have to be 20 or more consecutive weeks. We're just looking for 20 or more weeks in the current or preceding year, as in terms of figuring out what the number of employees your organization has. The Nebraska Department of Labor typically looks at the quarterly unemployment reports that employers submit to determine how many employees are on your payroll and for what periods of time. Generally, employees who are out of work due to a work-related injury or are otherwise on a leave of absence are still on your payroll and counted towards number of employees for purposes of this particular calculation. There is a related issue. If you have multiple entities that fall below the 20 employee threshold, the Nebraska Department of Labor might combine each of those entities for purposes of determining what your coverage is under the Act. Some of the factors that the Nebraska Department of Labor is going to look to determine whether these multiple entities that you have, that maybe one has 5 employees, maybe one entity has 7 employees, maybe another has 10 employees, whether the Department of Labor is going to combine all of those to determine what your number of employee threshold is. The factors they're going to look at are things like the interrelation of operations of those entities. They're going to look whether there's common management, common ownership or financial control. And then finally, and probably the most important of the factors, is whether there's a centralized control of labor relations. Sometimes we see this where we have a client that has multiple entities. Each entity has several employees, but there's only one entity that has an HR or an HR manager, and that HR person kind of serves as the HR person for all. In those types of settings, that's going to be one where the Department of Labor may look at those entities all as one for purposes of calculating how many employees that organization has.
So if you are an organization that thinks the way you're going to not have to comply with this law is by taking your company and splitting it into different LLCs or corporations, maybe have 9 work for one, have 7 work for another, have 6 work for another, and think that you're going to evade this law, chances are that will be unsuccessful. And the reason is the Department of Labor will just completely ignore the entities. It will say, how closely are these operations between these organizations related? And so are they swapping equipment? Are they working in the same building or close proximity? Who are the managers of those 3 entities? Is it the same individual kind of overseeing all 3?
Do they have the same benefits?
Yeah.
The same.
Yeah. So that's the biggest one, as Tara mentioned, the centralized control of labor relations. Chances are those three entities, just because the cost is so exorbitant to have different benefit plans, such as health insurance, life insurance, 401k for the three separate ones for those 3 small entities, you probably have one for all 3. That's a factor that indicates they're really just one entity for purposes of this law and most employment laws as well. So you may think you're outsmarting the Department of Labor, but chances are you're going to lose if you think that's the way out.
Okay, a couple more questions here today. The first one we'll talk about. is what time increments can we use to calculate the leave used?
So this is actually, I'll take the first one. That's actually addressed in the Act. The Act says that an employee may use paid sick leave in either hourly increments or smaller increments if the employer's payroll system accounts for absences in those smaller increments. But you have to at least provide them in hourly increments. So if you thought your way of not having to comply with this or a sort of out would be, you were gone this way for a doctor's appointment, I'm going to ding you for 8 hours of paid sick leave out of your bank. You can't do that if, in fact, your payroll system allows something for less, and you can't go. You have to at least give them at least an hourly increment. So understand that would be a violation under the Act if, in fact, you did that.
And that might be another reason why you want to have separate leave banks, because sometimes we'll look at employer policies who say paid time off has to be taken in at least 4-hour increments or 2-hour increments. That'd be a reason why you could kind of leave that as it stands for your PTO policy, but you need to have something different for your sick leave policy, since we've got to have it at least in hour increments.
All right, next question. What if an employee wants to loan her accrued paid sick leave to a coworker who is out of leave? Would that be permitted under the Act?
Great question. And this one's also pretty much covered by the language in the Act itself. The Act provides that at its discretion, an employer may loan paid sick leave to an employee in advance of accrual by an employee. So again, the Act sort of touches on this in terms of how our office has handled issues such as leave donation policies. We've typically advised against leave donation policies unless they're very carefully drafted. Here's the reasons why. We have had instances where certain employees will loan their accrued time to some employees and not to other employees. And that can become problematic if in the instances where an employee is loaning their leave, maybe that person is not in a protected class. And then other times they choose not to loan, and maybe that particular employee is in a protected class. That can potentially cause some issues for your organization. So we typically counsel against leave donation policies unless they're very carefully drafted and you've worked with your labor and employment counsel on that issue.
Keep in mind one related nuance, which touches upon what Tara said, is that, okay, under this law, let's go with a larger business, 56 hours. They bank that up, 56 hours. Let's say they didn't use any year one. Next year, they get another 56 hours. So they're now 112. Let's say that continues to the point where they have like 500 hours and maybe they only use a little bit here. All of a sudden, there's an employee, a coworker who gets sick, and they say, I want to give them my sick leave. And others want to do the same as well. At what point do you sort of try and get your arms around that as an employer to understand what kind of problems that creates when they're willing to give it to this particular employee because it's a very sympathetic situation and we like her. But when John down the street, maybe his situation's not sympathetic, we don't like John, we're not giving it to him or donating. Again, it just creates a lot of headache. It can be done, but I'll tell you, more often than not, it creates more problems than what it's worth.
All right, last question on this slide. Do employees accrue paid sick time while they are out on paid sick leave?
Interesting answer. Based upon the guidance issued by the Nebraska Department of Labor yesterday, which we have included as a handout on this particular presentation, the answer is yes. According to the Nebraska Department of Labor, an employee accrues the same benefits during time taken for paid sick leave as they typically earn during hours worked. And so if an employee is out for 3 consecutive days, or let's say a week, and they've exhausted 40 of their 56 hours that they have accrued that particular year, during that particular week, they're actually earning 1 hour, little more than 1 hour, because it's 1 for every 30 hours worked. And so that time they are not dinged, they're not prevented from continuing to accrue benefits even while they are out on paid sick leave.
This doesn't seem to touch on, though, a lot of times we'll see employer policies where perhaps they have like a general leave of absence policy that says the employer at its discretion may allow for an unpaid general leave of absence of up to, let's say, 30 days for certain circumstances. Again, if that is the leave that is being granted to the particular worker, a general unpaid leave of absence, I don't think that this touches on this, because this was specific to an employee accruing the same benefits during the time taken for paid sick leave as they typically take.
Yeah,
Would you agree
agreed,
with that?
agreed.
Okay.
So we've had a number of questions come in. We'll try and address at least one of them with the time allowed, and then we'll, at the end, on one of the last slides, we'll explain the process. So we want to hear from you of what other questions perhaps we didn't have a chance to answer today that we can answer on a future webinar. So the one question that came in, and I'm just looking off the slide here, why is it, do you think, that the Nebraska legislature created this act the way they did, and that was adopted by the voters, in which employees can accrue up to 40 or 56 hours and can continue to accrue that, and it rolls over so they can get literally hundreds of hours in their bank, but the employer doesn't have to pay it out upon separation? Is there a risk in the future that that could change? And Tara, Julie, I don't know what you think. There's always a risk, right? It could be that they decide to sort of move this into the same setting as the Wage Payment Collection Act. So you have an employee, let's say 5 years down the road, hasn't used any of their sick leave. They got more than 250 hours of paid accrued sort of sick leave in this bank, and all of a sudden the Nebraska legislature changes its mind and says, we want this to be treated just like PTO, you got to pay it out. That's a huge unfunded liability for many organizations. So understand it's legislative. It's always in limbo. It could continue to change, and we just can't predict in the future what may or may not happen. Thoughts? Okay.
I think it's an open question. Again, it's very clear that under the act today, you do not have to pay that out at time of termination. But would there be a change in the future that might address that differently? I think yes. I think that potential is there.
So it's interesting that this act does not apply to Nebraska political subdivisions, because we have a number of municipalities and other governmental organizations we represent that have very robust paid sick leave policies, where literally employees accrue thousands of hours. And even though not required to pay that out under the Nebraska Wage Payment Collection Act, by contract, by union contract, many collective bargaining agreements provide that if the employee leaves employment, they get all of that, or a percentage of that when they leave. And so we've had instances where employers are literally cutting checks of $20, $30, $40, $50,000 to employees for accrued sick leave. Again, that's an unfunded liability. If they don't have money set aside for that, it could be a huge ding to the budget. And so again, we want to see what happens there, but I'm just really concerned that in the future, the legislature could possibly change it so that that has to be paid out. We don't know that yet. We'll wait to see.
All right, next slide. Ben Franklin, I think, is the one who said an ounce of prevention is worth a pound of cure. Our advice, better to take some small steps now to prevent a problem from occurring. Take those small steps now as opposed to having the issue get bigger, having it be more difficult. What does that mean for you? Get your policies in order, have them reviewed by Labor and Employment Council to make sure that they comply with this act, and then train your supervisors and managers on what this new act requires and how your organization is going to handle it, and then train them again. Again, this is a major shift in leave laws in our particular state, and there's no amount of prevention there's no steps that you can't take now that won't be beneficial for you in the long run.
Just a short plug for our first Friday webinars. If you haven't already signed up to receive notice of those, we would encourage you to do so. If you haven't, again, the first Friday of every month at 11 a.m., except for next month, because it's the 4th of July. So we'll be doing that on Friday, July 11th. Here's why we mentioned this. And again, that QR code, if you take a picture of that, you'll be able to actually go in. It'll have the registration link. So you get emails. You don't have to attend them all. It'll simply notify you and ask you whether you want to participate. Next month, given the number of questions that have come in just today on this particular webinar that we just simply don't have time to get to, we're going to try and answer all those questions. If maybe tomorrow or a week from now or 2 weeks from now you think of additional questions under this act, send those to us. We will try to have our July webinar, again, that's going to be Friday, July 11th, be focused on additional questions, additional issues that have arisen under this act, and perhaps there'll be some additional guidance that comes out between now and then as well. So
hey, and something easy to remember, today's webinar was June 10th at 10. Next month's webinar will be July 11th at 11. So
she is so creative.
so hopefully that'll be easier to remember. Mark, you also want to talk about handouts?
Yeah, so again, we included as a handout on this particular webinar the guidance issued yesterday from the Nebraska Department of Labor. In about 48 hours, again, if you have a colleague who wasn't able to participate today, or you want to go back and catch up on some of this stuff, in about 48 hours, because it takes that much time for this to upload, we will have a video of today's particular webinar. We will have a PDF of the slide deck, which is before you now, as well as the Department of Labor's guidance from yesterday. We will have that on our website under the media tab. So give us about 2 days to get that up, and feel free to share that with anyone. They'll give you that information. And we'll also perhaps include information should you have additional questions that you want considered in the July 11th webinar at 11 a.m. Send those our way and we'll try to address those then. So on behalf of myself, Tara, and Julie, and our entire team, thank you for participating, and we're very grateful that you would consider listening to some of the guidance we've tried to give today. Thanks.
Thank you.
Thank you.